of a donor were fertilized during an IVF process. The embryos were then transferred into the uterus of the second applicant, resulting in her pregnancy. Consequently, twins were born to the applicants. According to the impugned provisions, the children are regarded as the children of the second applicant. Only she has established rights and responsibilities, duties and obligations towards the children. The recognition of the rights and responsibilities of the second applicant towards the children is premised on the fact that she gave birth to them. The first applicant is vested with no such rights and responsibilities, despite the fact that she and the second applicant are permanent life partners who jointly took and executed the decision to have children. The first and second respondents are the Minister of Social Development and the Minister of Justice and Constitutional Development, respectively. The ministers did not oppose the application in the High Court and abide the decision of this court. The Centre for Child Law participated in the High Court proceedings as amicus curiae and are admitted in that capacity in this court. In this court, the applicants contend that the impugned provisions A. constitute unfair discrimination on the basis of marital status and sexual orientation, B. they violate the dignity of the applicants and others in their position, and C. are not in the best interests of the child. First, the applicants argue that the impact of unfair discrimination occurs when a burden is imposed on people who have been victims of past patterns of discrimination, such as women, people of color, gay people, or unmarried people, or whenever the fundamental dignity of a person is violated. Where the discriminating law or action is designed to achieve a worthy or important societal goal, it could make fair what would otherwise be unfair discrimination. They contend that there is no conceivable worthy societal goal that the state can achieve by excluding the first applicant and others similarly situated from being regarded as legal parents. The applicants accordingly say that the discrimination against the first applicant is based on both her sexual orientation and her marital status. Second, in respect of their claim that the impugned provisions encroach on their right to dignity, the applicants rely on Dawood, who is Minister of Home Affairs. There it was held by this court that the right to dignity must be interpreted to afford protection to family life. The applicants argue that despite the Constitution not containing an express right to family life, this court, in ex parte chairperson of the Constitutional Assembly, said that this right is indirectly protected by the right to dignity. Thirdly, the applicants argue that the best interests of their children are not considered in the impugned provisions. They rely on Fletcher versus Fletcher, where the appellate division held that the most important factor to be considered in matters concerning custody and excess are the best interests of the child. They contend that it would be in the best interests of their children for them to be regarded as the legal children of both the applicants. They further argue that it's important that the first applicant be regarded as the legal parent of the children. This is for many reasons, including the rights but also the responsibilities which are granted to and expected of a legal parent, which would otherwise not apply in this matter, thereby disadvantaging the child. The CCL agree with most of the submissions made by the applicants, save for two issues. First, they dispute that the impugned provisions discriminate on the basis of sexual orientation. They say it discriminates against unmarried people in a committed relationship, and that this is not constitutionally justifiable. Second, the CCL raised concerns in respect of the proposed remedy. Its argument is that the inclusion of the words "or permanent life partner" as a long-term measure would not properly cure the defects identified, as the term is open to varying interpretations and could lead to uncertainty, which would in turn undermine the best interests of the child. In a unanimous judgment penned by myself, the Constitutional Court confirms the audit of constitutional invalidity made by the High Court. In doing so, it says that traditional notions of family and parenthood have undergone a revolutionary change under our constitutional dispensation. This can be attributed to a number of factors: the strong commitment to inclusivity and equality our Constitution evinces, the celebration of diversity as a source of richness rather than of division, and the recognition that for individual autonomy to flourish, it must be enabled to be expressed in its fullest form. If pre-constitutionally South Africa was characterized by an obsession with difference and exclusion, then the post-democracy era must represent a triumph for inclusion and diversity. This case is about whether the impugned provisions of Section 40 of the Children's Act are consistent with the Constitution. The Court holds that the impugned provision singles out marriage as the only relationship that the law recognizes, and then assigns parental rights and responsibilities to married persons only in respect of a child born as a result of artificial insemination. In our constitutional dispensation, the emphasis has shifted away from the form of a relationship to its substance, to the caring and the commitment that is found within it, to the family that lives and thrives within it, and to the dignity and self-worth of the people who find themselves within it. This is consistent with the values of equality and dignity that stand at the forefront of our constitutional order. Accordingly, the Court finds that the impugned provisions create a differentiation of treatment applied to two different categories of persons, married on the one hand and unmarried on the other. As the differentiation is on a specified ground for the purposes of Section 9, subsection 3 of the Constitution, namely marital status, it would constitute discrimination and would activate the presumption that the discrimination is unfair. Further, this Court finds that the impact of the discrimination on the basis of marital status is far-reaching. The message that this conveys is that although permanent life partners have made the conscious decision to enter parenthood, such a choice is less respected than the same choice made by married partners. Its impact renders it manifestly unfair, and this Court accordingly concludes that the impugned provisions result in unfair discrimination on the basis of marital status. On the basis of whether the impugned provisions unfairly discriminate on the basis of sexual orientation, the Court finds that in the category of persons excluded by Section 40, not all heterosexual life partners would experience the exclusionary effect of Section 40. This is because a relatively small percentage of parties in such a relationship would have experienced infertility and therefore would need access to artificial fertilization. On the other hand, it is biologically impossible for two females to reproduce coitally. They are entirely reliant on artificial fertilization process and by implication Section 40 of the Children's Act to realize their dream of becoming parents to their biological children. Two men in a same-sex partnership would not rely on Section 40 of the Children's Act for the conception of their biological child, as neither man would be capable of being artificially fertilized. Lesbian life partners who seek to have biologically related children have no other alternative but artificial fertilization. The automatic assignment of their rights and responsibilities would accordingly, purely on the basis of their biological reproductive constraints, be exclusively governed by the impugned provision. Lesbian permanent life partners are therefore disproportionately affected by the differentiation occasioned by the impugned provision. This Court has previously recognized in Pretoria City Council v. Walker and confirmed in Mashlangu v. Minister of Labour that, quote, a seemingly benign or neutral distinction that nevertheless has a disproportionate impact on certain groups amounts to indirect discrimination. It is on this basis that this Court takes the view that the differentiation on the basis of sexual orientation nevertheless constitutes indirect discrimination. In Mashlangu, this Court, in speaking to the intersectionality of discrimination, said it required no more than an acknowledgement that, quote, discrimination may impact on an individual in a multiplicity of ways based on their position in society and the structural dynamics at play, close quote. This Court finds that there can be no legitimate governmental objective for the differentiation between homosexual and heterosexual relationships. It must therefore follow that Section 40 of the Children's Act violates Section 9(1) of the Constitution and indirectly discriminates against the applicants as lesbian permanent life partners on the basis of their sexual orientation. The court in Dawood versus Minister of Home Affairs confirmed that the right to dignity included the right to family life. It held that the dignity of the parties had been infringed upon as the impugned provision impeded the achievement of personal fulfillment. Here too, the applicant's right to dignity and by extension family life has been limited in that they are unable to, through the choices they have made, achieve the fulfillment of parenthood. This court finds that Section 40 diminishes the worth and the value of the applicants by saying that they are not worthy of being treated in the same manner as their married counterparts and constitutes a limitation of the right of the applicants to have their dignity respected and protected. This court then finds that Section 40 of the Children's Act treats children born of unmarried persons differently than from those born of married persons. In Centre for Child Law versus Director General, the Department of Home Affairs, this court held that such differentiation and such differential treatment to be invidious and unconstitutional. This court further held that the differentiation between children based on their status of being born out of wedlock is not consistent with the best interests of the child principle. The court accordingly finds that it is being compellingly demonstrated that the impugned provisions are not consistent with the best interests of the child and limits their fundamental rights. The court finds that the limitation of the applicants and their children's right to dignity, equality, and to have their best interests considered is not justifiable in terms of Section 36 of the Constitution. Accordingly, Section 40 is declared unconstitutional to the extent that it excludes permanent life partners as automatic recipients of parental rights and responsibilities. In the result, the following order is made. 1. The declaration of constitutional invalidity of Section 40 of the Children's Act made by the High Court is confirmed in the terms set out in paragraphs 2, 3, 4, 5, and 6 of this order. 2. It is declared that the impugned provisions of the Children's Act unfairly and unjustifiably discriminate on the basis of marital status and sexual orientation by excluding A. or permanent life partner after the words spouse and husband wherever such words appear in Section 40 of the Children's Act, and B. or permanent life partners after the word spouses wherever such word appears in Section 40 of the Children's Act. 3. The declaration of constitutional invalidity referred to in paragraph 1 takes effect from 1 July 2007, but its operation is suspended for 24 months from the date of this order to afford Parliament an opportunity to remedy the constitutional defects giving rise to the constitutional invalidity. 4. From the date of the order of this court, Section 40 of the Children's Act will read as follows. The underlined words being read into the section as it is currently formulated. 1. Small a. Whenever the gamete or gametes of any person other than a married person or his or her spouse or permanent life partner have been used with the consent of both such spouses or permanent life partners for the artificial fertilization of one spouse or one permanent life partner, any child born of that spouse or permanent life partner as a result of such artificial fertilization must for all purposes be regarded to be the child of those spouses or permanent life partners, as if the gamete or gametes of those spouses or permanent life partners had been used for such artificial fertilization. B. For the purposes of paragraph B, it must be presumed until the contrary is proved that both spouses or permanent life partners have granted the relevant consent. 2. Subject to Section 296, whenever the gamete or gametes of any person have been used for artificial fertilization of a woman, any child born of that woman as a result of such artificial fertilization must for all purposes be regarded to be the child of that woman. 3. Subject to Section 296, no right, responsibility, duty, or obligation arises between a child born of a woman as a result of artificial fertilization and any person whose gamete has or gametes have been used for such artificial fertilization, or the blood relations of that person, except when A. that person is the woman who gave birth to the child, or B. that person was the husband or permanent life partner of such woman at the time of such artificial fertilization. Paragraph 5, in respect of the period 1 July until the date of this order, the following shall be the position. A, the reading in provided for in paragraph 4 will not apply to persons who were permanent life partners at the time of the artificial fertilization, unless they invoke the benefit of this order by a written declaration signed by both of them. In such event, the provisions of section 40, subsection 1A, as read in, will apply. B, in the event that rights and responsibilities in respect of the child, children so born, has been assigned to any third party or parties in terms of the Children's Act or any other legislation, or enjoyed by a former partner of the permanent life partnership only, then 1, the party seeking to invoke the benefit of this order will give written notice to the parties of the former partner of their intention to do so and afford the third party with an opportunity to object thereto. If the third party or former partner objects in writing thereto, the matter must be referred to the Children's Court, which will determine the procedure to be followed and issue appropriate orders and directions within its powers. And then Roman 3, the Children's Court, after considering the matter, may make any order that is just and equitable, and in doing so shall be guided by what the best interest of the children in question require. Paragraph 6, in the event that Parliament does not remedy the constitutional deficiency in section 40 within the period provided for in paragraph 3 of this order, or any extended period granted by this court, section 40 will be deemed to be read as set out in paragraphs 4 and 5 above. And then finally, paragraph 7, the respondents are to pay the applicant's cost in this court, including the cost of 2 counsel. I hand down the judgment. Today, the Constitutional Court hands down judgment in an application for confirmation of a declaration of constitutional invalidity made by the High Court, Johannesburg. The High Court held that Section 4 of the Mediation in Certain Divorce Matters, Act 24 of 87, is unconstitutional in that it unfairly discriminates between children of married parents and those of never married parents in the manner in which their best interests are investigated by the Office of the Family Advocate. The applicant in this matter is the Centre for Child Law, a registered law clinic based in the Faculty of Law at the University of Pretoria. The CCL appeared as amicus curiae in the High Court, where Mrs. T.S. was the applicant. On or about 18 September 2020, Mrs. T.S. launched a substantive application before the High Court in 2 parts. In Part A, she sought an order directing the Family Advocate to investigate the best interest of her minor children vis-à-vis their possible relocation to Australia. In Part B, she sought an order permitting her to relocate to Australia with the minor children. Mr. NB opposed both parts of the application and proceeded to institute a counter-application wherein he sought an order for his home to be the primary residence of the minor children. Mrs. T.S. and NB are unmarried but are the parents of the minor children. The Minister of Justice and Correctional Services, who appeared on behalf of the Family Advocate, was joined to the proceedings at the instance of the High Court. Part A was set on the opposed motion roll and was allocated to Poseidon Note AJ, who on 21 September 2021 issued directions to the parties raising the constitutional validity of Section 4 of the Act, stating that the section appeared to make an arbitrary distinction between children of married or formerly married and divorced parents and children whose parents have never been civilly married, and was thus inconsistent with the various provisions of the Constitution and with the Children's Act of 2005. Addressing the issue of constitutional invalidity, the High Court held that in determining whether the Act unfairly discriminates and offends against the rights of never married parents and children born from never married parents, it had to apply the Hodgson test. After applying the test, the High Court indicated that it is common cause that the Act only applies to divorcing or divorced parents. In that regard, never married parents are not entitled to rely on the provisions of the Act to simply enlist the services of the family advocate after the institution of a legal process by completing a standard form. The Court indicated that the category of never married parents and their children are treated differently by the Act. In ascertaining whether the differentiation bore a rational connection to a legitimate governmental purpose, the High Court found that the differentiation previously served a legitimate purpose in the past because at the time the family advocate was established, the divorce rate was increasing in South Africa, and there was an urgent need to protect the interests of children under those circumstances. However, that presently as a society is no longer necessary, as the institution of marriage in our country is no longer a prerequisite for children to be regarded as legitimate. In declaring the impugned provision unconstitutional, the High Court stated that there can be no legitimate governmental purpose for the differentiation based on marital status when it comes to the treatment of children. Before this court, the CCL argues that the family advocate services are in the case of divorcing or divorced parents provided on demand. The parent, when initiating proceedings or any time thereafter, simply completes a form that corresponds substantially to Annexure B of the regulations made under the Mediation in Certain Divorce Matters Act and the Family Advocate. In turn, initiates an inquiry in terms of Section 4 of the Act. The CCL argues that this simple, streamlined and cost-effective procedure is not available to unmarried or never married parents in that it unfairly discriminates against them and the children of those parents on the listed ground of marital status. The CCL submits that this in turn violates the right to equality, human dignity, and the right of a child to have their best interests considered of paramount importance. Mr. NB is represented before this court, but states that he will unreservedly abide this court's decision. He states that he merely sought to submit an alternative argument so as to assist the court in coming to a well-considered just decision. Mr. NB argues that the differentiation created by the impugned provision is not as a result of unfair discrimination, but rather flows from the legal consequences of the choice married and formerly married parents made to get married. Furthermore, that never married parents must look to the Children's Act to engage the services of the family advocate as it represents suitable alternative options. The Minister also indicates that he would abide the decision of this court and has made submissions only in relation to cost. In a unanimous judgment penned by Justice Chiki, this court holds that the impugned provision does indeed treat divorced or divorcing parents differently in the way it treats never married parents and married parents who are separating but not divorcing, and that this establishes differentiation. In determining whether the impugned provision has a legitimate governmental purpose, this court holds that there is no such purpose for devising a simple streamlined process for divorced and divorcing parents, while withholding that simple streamlined process from unmarried parents going through a separation or who simply cannot agree on how to deal with the interest of their children. In rejecting the choice argument advanced by Mr. BN, and after analyzing various provisions of the Children's Act, particularly sections 23, 28, and 29, this court finds that it gives both married and never married parents the right to approach a court to seek its intervention, so that a family advocate is appointed to furnish a report to the court regarding issues around children's interest. In terms of section 23, 28, and 29, a party in Mrs. T.S. position can approach a court for the extension of parental responsibilities and rights and the simultaneous termination, suspension, or circumscription of the father's responsibilities and rights regarding the children. In these proceedings, in terms of section 29, subsection 5, the court hearing the matter can order the family advocate to inquire into the best interest of the child and produce a report with recommendations for the purposes of the hearing. Furthermore, the court can order the family advocate to attend court and give evidence. This court finds that the family advocate cannot get involved without a court ordering it to be involved, whilst in divorce proceedings, it gets involved through the mere submission of Annexure B. This court further holds that the Children's Act thus prescribes a process which is available to both married and never married parents, whilst the Act does not afford never married parents the right to utilize a process similar to that available to married persons who are going through divorce. Practically, married persons who wish to get divorced may use the process prescribed in Section 4 of the Act by simply completing Annexure B when summons is issued and file the annexure simultaneously with their divorce summons. Following the filing of Annexure B, the family advocate becomes involved in the divorce proceedings in order to provide the court with a report on the interests of the children affected by the divorce. However, this court holds that conversely, unmarried parents cannot simply complete Annexure B when they separate, in that they have to utilize a two-tier process that effectively seeks leave of the High Court to appoint the office of the family advocate to mediate in the issues pertaining to the child or children. Thus, this court finds no merit in Mr. Bien's arguments. This court thus holds that there is no doubt that the impugned provision limits sections 9.1 and 9.3, as well as the rights of affected parents and children in terms of section 10 and 28 of the Bill of Rights, and that the limitation is not justifiable in terms of section 36 of the Constitution. As a result, this court confirms the order of constitutional invalidity and makes the following order. 1. The order of the High Court, Gauteng Local Division, Johannesburg, declaring Section 4 of the Mediation in Certain Divorce Matters Act to be inconsistent with the Constitution and invalid is confirmed to the extent that it precludes never married persons and married persons who are not going through divorce and their children from accessing the services of the Office of the Family Advocate in the same manner as married parents who are divorced or going through divorce do. 2. The declaration of invalidity referred to in paragraph 1 shall not be retrospective and is suspended for a period of 24 months to enable Parliament to cure the defect in mediation in divorce matters, giving rise to its invalidity. 3. During the period of suspension referred to in paragraph 2, the Mediation in Certain Divorce Matters Act shall be deemed to include the following additional provision, quote, Section 4, capital A, 1, the family advocate shall, small a, after an application has been instituted that affects or is likely to affect the exercise of any right by a parent or non-parent with regard to the custody or guardianship of or access to a child, or after an application has been lodged for the variation, rescission, or suspension of an order with regard to any such rights, complete Annexure B to the regulations, if so requested by any party to such proceedings, or the court concerned, institute an inquiry to enable them to furnish the court at the hearing of such application with a report and recommendations on any matter concerning the welfare of each minor or dependent child of the marriage concerned, or regarding such matter as is referred to them by this court. 2. Any family advocate may, if they deem it in the interest of any minor or dependent child concerned, apply to the court concerned for an order authorizing him or her to institute an inquiry contemplated in subsection 1A. 3. Any family advocate may, if they deem it to be in the interest of any minor or dependent child concerned, if so requested by a court, appear at the hearing of any application referred to in subsection 1A, and may adduce any available evidence relevant to the application and cross-examine witnesses giving evidence thereat. 4. Should Parliament fail to cure the defects within the 24-month period mentioned in paragraph 2 above, the reading in will continue to be operative. And then finally, paragraph 5, the third respondent, in brackets the minister, close brackets, must pay the applicant's cost in this court and the first respondents in the High Court, occasioned by the filing, audit and submissions, and the hearing of the 10th of January 2022. I hand down the judgment.